that we deliberate extensively and we get to a point where we can move closer to the finalization of the bill. Our members, let me invite then the Parliamentary Legal Advisor to make the presentation on the proposed amendments on the bill, and then the committee will then deliberate after that. Dr. Lutz, if you can.
Thank you, Chairperson. Good evening, Honourable Chairperson. Good evening, Honourable Members. I just want to check, Chair, Gershwin was going to, oh, there it goes. I see he has the slide up. Chair, thank you for this opportunity. Like you said, we've had some discussions with the department, taking into consideration the SAP submissions, public hearings, and the MPA. If I could ask Gershwin just to go to slide 3, please. One back. Thank you. Chair, with our Constitutional Legal Services Office looks at the drafting, looks at constitutionality, and where we have a mandate from a committee to interact with the department, we do so. And the primary focus of our interaction with the department on this bill was clause 16, and then the gender neutrality issues that needed to be addressed throughout the bill. Just to recap, members, the bill is following international trends that has a changing nature in cybercrimes, and South African law needed to reflect that, and the legislation, the consequential legislation through this cybercrimes bill needed to be updated, and certain crimes needed to be created, which is the purpose of this bill. It looks at jurisdiction, it imposes obligations where it is necessary, and looks at mutual cross-border assistance with foreign countries as well. My aim in this presentation is not to dive into the policy of the department. They are more clued up than I am with regard to what the reasons behind the inclusion of a clause is, as well as the law that went into the discussions for its inclusion and the creation of the bill. So, with permission, Gershwin, if I can go to slide 4, please. The gender neutral issue, the bill referred to he or she, and specifically in clause 16, it was highlighted that we needed to take into consideration identity and gender neutrality, dignity that not everybody associates as a he or she. Some people choose to not associate as either, and therefore we talk about non-binary language. So throughout the bill, members will see we are proposing or recommending that where it reads he or she or any associated his or her or he, she or it, him or her, that we use a singular they. It sounds odd on the ear. We have had lengthy discussions on that, and it's quite trend setting this bill in choosing this way of speaking, because the they then puts it grammatically not in the traditional format, but where we will then say he or she would like to in a normal sentence, and instead of he or she, we'll say they would like to. So members will see that throughout. Also, the he or she, there's still the slight gender debate is why is the he first, so you have the masculine rule. So we're avoiding all of that and coming into line with the new trends of the Commonwealth countries in using they as a singular. Also, just then on slide 4, to highlight some of the drafting principles, our aim as the Constitutional Legal Services Office is to help the bills also read as plain language. In terms of the plain language, sorry, it's slide 5. I'm getting my numbers crossed here. I don't have enough coffee in my system for this meeting, and it's so late. So plain language, that means we are aiming that is a very complex bill, because it's a complex form of law or category of law, must be as readable as possible to any person picking it up. So if the person is not a cybercrime specialist, the person must still be allowed to understand what is the crime, what may not be done, how they are supposed to act, how they are supposed to sit in the same with the police and everybody else involved. So we try to tweak it a little bit with regard to readability and the structure of the clauses. We look at clauses that read easier when you put the subject first, so the person or the judge or the court and what they must do is the action, and then provide the context in a clause. So members will see it looks like we had a red pen like go throughout this bill, but we just kind of restructured it so that it reads easier in that subject action context sequence where we could. This was not doable everywhere because we're working on a bill that already has a structure. So we incorporated that without like throwing the structure of the bill out, that it loses its main purpose and crux. Then if I can take members to clause 1, the definitions, which is in slide 6. There the insertions of article and a police official or a responsible person that the department already spoke to in the meeting of the 11th of March. What was done consequentially in that is certain provisions were taken out in the referencing of legislation. So National Commissioner, we tweaked that a little bit with just how the legislation was referenced. The same with National Director of Public Prosecution, police official. We added a definition for constitution, so you don't have to write out the Constitution of the Republic of South Africa 1996 throughout. It becomes quite wordy, so we had a definition added for constitution there as a proposal. There was a few definitions added from the department side on the 11th of March of electronic communication related issues. And then, yeah, the South African, especially designated police officials were also further just clarified. The importance of the definition clause, it's the tool with which the Act is interpreted throughout, unless there's a certain specific definitions included in a clause itself. It speaks to just that clause or just that part. So the definition section is very important, and we try to clean that up as much as possible. In speaking to the department also, we realized that some of the legislation being referred to does not need to be referred to. We had the Labour Relations Act there, for example, and it doesn't deal with such matters. It doesn't touch on such. So that has been deleted, members will see. Then with permission, Chair, if I can move on to slide 7. Thank you, Gershwin. Members will see there it deals with unlawful access. The crux or the content substantially stays the same as it was like presented by the department. Just to remind members that it is now reading in a subject action context. So members will see in subclause 1, it starts with any person who, and then again into A with any person who, and then it gives the purpose and the action and the context. So that's just the sequence of the section that has changed. It still deals with unlawful access. And we have discussed this quite lengthy. I also agree with the position taken in that clause. Then in clause 3, the unlawful interception of data. Also, again, as the department presented on the 11th of March, just to highlight to members that that clause then adds the phrase or the output of data. So it just clarifies the scope of the application of that clause even further. Then on slide 8, we look at clause 4. The unlawful acts in respect of software or hardware tools. These are consequential amendments to align with the restructuring of clause 4 with clause 2. So because the numbering has changed, we needed to have the consequential amendments reflected of clause 2 in clause 4. Members will see that happening quite frequently in the proposed amendments that we have. Then for clause 5, Chair, it calls for an insertion of held in the computer system or a computer data storage medium. It provides just a further proper context within which the clause is to be applied and read. Then with permission, if I can go on to the next slide, slide 9, please, Gershwin. Thank you. The clause 6 is also a technical, just a technical grammatical error. There was a of at the end of a few of the subcategories, and we just moved that of to one place so that it doesn't look like so the of as a word is not repeated. So
am I the only one who lost the sound?
Dovu, there's some other background music. Honorable Dovu, if you can hear me. Honorable Dovu? Joshua, is he still with us?
I believe so, Chair. I believe it's still on. I'm not
Okay,
sure if we can hear the presentation though.
Can you liaise with him? And we'll continue. Barbara, sorry for the interruption.
Thank you, Chair. I apologize as well. It's raining in Cape Town, and we just had a hailstorm as well. So I don't know how the weather elements impact the presentation or the audibility. So my apologies for that if there is. Chair, if I can just point the members then to clause 7. There, it's also been a restructuring, and perhaps just to highlight to members that we have something called a sandwich clause. It sounds very odd, but we call it a sandwich clause in drafting, where you start a sentence, you have a sub A, B, C, D, E, and then you end the sentence, so it goes on. And in the original as tabled, there was the sentence didn't close, it went on to another sub and Roman numeral 1, 2, and so on. So just for readability, we collapsed that last 2 points into one, so that the context is clearly the end of that sandwich provision in structure. So nothing changed there substantially from what was otherwise tabled in that, and it just helps, it aids with readability. Then, Chair, with regard to the, I can just if we can go on to the 10th slide, please, Gishrin. Cyber fraud, it's a small technical a change there. Again, it's a collapsing of the one, just to not have too many subs with that aren't like flowing subsections of each other, but difference in style. We have that, so it's just a small, the A and the B is a technical amendment to make it grammatically correct. And the same in with aggravated offences, clause 11. It's also basically clause 8, 10, and 11 all have those slight drafting issues or adjustments in there. And then also to point out in clause 11, as it's presented by the department on the 11th of March, there in subclause 2, there was a longer list of endangered the life, cause a serious risk, cause the destruction of, or substantial. It was a long list of possible scenarios outlined for a person who commits an offence referred to in 5161 or 10. So it's just cross-referencing who knows or ought to reasonably have known that or suspected that the offence in question will cause that harm. So during the public hearings, it was pointed out that that list is too vague. It's too broad. The application of it is uncertain. So the department then tightened that up with just 3 subcategories of endangering the life or cause serious bodily harm, cause serious risks to the health or safety of the public, or create a serious public emergency situation. So that's just more concise and to the point. And then with the subclause 3 there, we just did the restructuring of subject, action, and context again. Then with permission, if we can move to slide 11. There, clause 13 is a definitions clause that falls into part 2, which deals with malicious communication. And to provide further clarity in the scope of this part and the sections that speak to it, the department added the definition of disclosures in there, and I agree with the scope they added to that. Then clause 14, data messages which incites damage to property or violence, that follows the amendments there reflected, follows the fact that we now have disclosures defined in clause 13. So we can tighten that up then in clause 14 and just work disclosures in there. And then with data messages in clause 15, which threatens persons with damage to property or violence. That's also just restructured for readability, so we didn't touch that in substance. Then comes the clause that we on slide 12 that we really we grappled with this one. We had various debates. We spoke to through the department, the DOJ got inputs from the MPA. So this has been a clause that has been looked over and over and over again. And we think we found a way to address a more inclusive way of phrasing the approach, taking into consideration gender neutrality, dignity, identity, again, the non-binary considerations. And we have qualified the scope to read to the intended purpose, and have the consequential amendments with regard to an electronic communications service. But if I can go to clause 13, and just this is an update to the slides members have. I've actually included in slide 13 the provision, just to show, because it has changed slightly since we circulated the discussion document. So members will see there in subclause 1, we're saying any person who unlawfully intentionally discloses, bring in that definitions, a provision by means of an electronic communications service, a data message of an intimate image of a person without the consent of B is guilty of an offence. So we're creating the offence there. Then in sub 2, we say for purpose of subsection 1, so for purposes of the offence created, B means the person who can be identified as being displayed in the data message, any person who is described as being displayed in the data message, irrespective of the fact that there we use the he or she instead of using they, because the previous clauses or subclauses uses the person or any person. We then say of the fact that the person cannot be identified as being displayed, and then in Roman numeral 3 there, any person who can be identified, context to who B can be. And then if we go on to clause 14, here's the part where we really worked on it, is what is an intimate image, because the scope of intimate image needs to be very clear. If the disclosure of an intimate image is what you are making the wrong or the crime. So for here we had intimate image means a depiction of a person, real or simulated. So if something has been tampered with, the image has been tampered with and made by any means in which B, as described previously, is nude, or then taking the his or her out for non-binary purposes, the genital organs or anal region of B is displayed, or if B is a female. Initially, the clause as tabled just said female breasts are displayed. And then during the public hearings, there were questions about this is not broad enough, where people don't identify as just male and female biologically. There are other situations. So we made that a female person. Then, as was pointed out by the department in the presentation of the 11th of March, added transgender person. During the consultations of the MPA, they spoke about the inclusion of transsexual person as well. And because there are situations biologically where people have both male and female biological parts, but don't identify as either, we also used intersex just to cover that biological reality that exists sometimes. On reflection of the transsexual and with further discussions with the Department of Justice since the document was circulated, transsexual person is actually a specific subcategory of transgender person. Transgender person is a broader category that somebody can identify as a transgender person. That transgender person can also be a transsexual person. So upon reflection, to have the general and the specific description in there, it's now opted that we just use female person, transgender person, or intersex person where their breasts are displayed. The same then goes back to the subcategory BB. The same will then be reflected there, the covered genital or anal region of B, or if B is a female person, transgender person also are displayed. And here comes the qualification, because there was a concern that the clause may be too wide, and then it had unintended prejudicial impacts. Say in Men's Health, if somebody poses and any other magazine, I can't think of a magazine at the moment, or somebody's on the beach and there's a photo taken, all of those scenarios are thrown around. So just to make sure that the intent of the crime and the qualification and what it is focused on is clear, Roman numeral 2 now reads, in respect of which B, so displayed, retains a reasonable expectation of privacy. So B must think that this is not for everybody. It's not that supposed to be public at the time that the data message was made. And the data message must be made in a manner that violates or offends their sexual integrity or dignity or amounts to sexual exploitation. So that just provides the context of why. So the intimate image that is sent through a data message must be for such malicious. The clause 16, as we are proposing it for amendment to the committee, which was our biggest task in re-looking at the bill. Then to just continue to clause 17 on slide 15. Thank you, Gershwin. Oh, sorry, 17 we didn't touch. We're on 18. I'm not referencing the clauses that we didn't touch that are as tabled through the NA to the NCOP. So members will see the sequence sometimes looks a bit strange. So clause 18, it's a consequential amendment again that aligns with clause 2, some technical readability changes. We didn't really fuss too much about it. Again, just like with in the 2A, a contravention of, to B, a contravention of, we just like bulk all together and put it at the start of that list so that it doesn't look like a repetition. In clause 19 then, with regard to sentencing, I can just get there. The sentencing, again, members will see the clause 2 consequential amendments and aligning. And then the clause 6 and 8, some tweaking there as well, just again for readability and to make it clear and in line with what the department wanted there, how the scope of those clauses should be. Then on page or slide 16, we're looking at clause 20, very much as the department in policy and law presented it to the committee on the 11th of March. It still provides for the protection orders that's linked to clauses 14, 15, and 16. So the crimes that are set out there with regard to malicious communication. There's an inclusion in 2012 with a reference to the host of the data messages to make it sure that there's the scope and the application of that is clear with the protection orders, and then non-binary grammatical amendments have been effected. So we have not touched the law as set out there by the department. That would be the same situation here with permission in clause 21 and 22. Which is 17 and 18. Also, same as the department has presented it, we have just done a few grammatical non-binary changes. The clause title in clause 21 has been changed as well, just for clarity, and that has been done in consultation with the department. So with 21 and 22 on slide 18, we didn't really change the law and the policy as they wish it to be reflected there. On clause 19, we then look at penalties, and the penalties as well. We just have a technical consequential adjustment again here to align with clause 22 because there was some restructuring done there without touching the substance much. Clause 24 with jurisdiction. The department there on 11th of March presented it to extend the court's jurisdiction, so that remains the same, to make allowance for transnational dimensions of cybercrimes that I haven't touched is still all there. So what they wanted to extend with regard to the jurisdiction and what they wanted to highlight, I haven't touched, and I agree with their reasoning there. It seems sound. Eventually on page 20, we have another slide 20, we have another definitions clause that falls in a different part. It speaks to the powers to investigate, search, access, and seize. So now we've done the crimes. We have highlighted that, and that has been defined, so everybody knows what they can't and can't do. The jurisdiction of the court has been established, and the penalties. And now we are with regard to how this is all going to, how people are going to be tracked, how the evidence is going to be gathered. That's then with the definition of access. The department on 11 March just tweaked the definition of access slightly, and that's then also reflected with the standard operating procedures. The only change there that we may want to highlight again is the department on the 11th of March said that 6 months to get the SOPs up and running is changed to 12 months. And then apart from that, we just made a slight structural change in a reading in saying 2 investigators in the investigation of, just to add to the flow. With regard to clause 29 and 30, also just non-binary grammatical amendments, slight tweaks for readability. We didn't change anything with regard to the substance of the clauses, as the members have already been briefed on those. And with clause 32 and 33 on page or on slide 22, these just speak to the submissions of the subs. The DOJ on the 11th of March addressed those, how they incorporated that, how it affords the police the power to act and what the requirements are. All we changed in that or recommending, and that is a non-binary grammatical amendments in addition to the presentation of the 11th of March. Then with regard to slide 23 with clauses 35 and 37, there is in 35 it's non-binary amendments. In 37 there was an oversight with regard to clause 37B Roman numeral 1, where it just said computer instead of computer system. So that clarification for qualification for computer to make the intended scope and application clear was just added. On slide 24, we're just highlighting again that as the DOJ has presented it, we're not touching that. Some technical amendments, some non-binary changes there. Clause 40, interception of interdict communication. 25, it has technical amendments for clarity. Members will see in clause 40 sub 4, there's amendments substantially similar to how the clause was tabled. But just to get a better contextual nature in discussion with the DOJ and an agreement with them, that there has been certain, the reading is different. It addresses the economic communication service providers' concerns as well. And the proposed amendments clarifies and it takes out ambiguity. So that is just, it may look different, but the substance is still the same. The context and nature is just clearer. On slide 26, dealing with clauses 41 and 42. 41 is technical amendments, non-binary, and clause 41.1, members will see it has just been restructured to be more concise for the purpose of clarity and readability. The substance is still the same.
Members, Barbara. Members, can you please unmute?
Then that was the just 41 and 42. It was restructured for readability and clarity, so it looks a little bit different, but the substance is still the same. On slide 27, Chair, there is the amendments proposed in clause 43. Sub 1 and 3 are amendments that are non-binary and to provide also clarity and aid interpretation. With clause 44, the consequential amendment there is to align it with the definition of data, which is important just to give a proper indication of the scope and the application of the section. It clarifies different requirements for disclosure of data. It extends the ambit of application to data available to a computer system, and then it has non-binary amendments. These are all it's still the same and on track with what the department presented on the 11th of March, so the substance is still the same. It was just tweaked slightly. So at slide 28, deals with clause 48 and 49, also just non-binary cross-referencing amendments in clause 48 that was brought in and corrected. The rest are just standard non-binary technical insertion there in clause 44 of a comma that was a bit rogue, and we put that in. On slide 29 with clause 50 and 51, technical as well, cross-referencing affects there, and so just to make sure that the bill is tight, that people can link it with the relevant sections and know what to read with one another. Also, then for just the purpose of somebody picking up the act and knowing where to look. On slide 30, it is there was just in clause 53 sub 3b Roman numeral 2, there was a substitution of or for and, so just to make sure that people read that together and not as alternatives. And that was pointed out by the department and added, so we added that. Clause 53, the non-binary amendments again, the technical sandwich clause provision. There we made in clause 54(1)(fi) to make sure the designated reads as the latter part of the sentence, not part of the subcategory. So designated was just shifted. It's always been there. It was just shifted in structure for readability. In 31, slide 31, it is a few grammatical amendments in 55, clause 58, the regulations. The department on the 11th of March extended the scope to include clauses 20 or references to clauses 22.5 or clause 22 sub 5 and sub 7. That's still there. We didn't touch it. In clause 60, the short title, it is just cleaned up that the 2019 now reads 2020. And then the schedule. I didn't change anything. The department, as it is, has it there. They, because they are the administrators of the acts, they know how the bill's content will reflect an impact for cross-referencing purposes on other legislation. The drafting principle is not to amend the style or the substance of another act through a schedule in legislation or in a bill that's being passed. So as the DOJ can explain if they want to further, it's really just carrying the context of the bill in a reference through to the already existing pieces of legislation that's relevant to these crimes, so that the bill that comes in now also is part of that package. Chair, that is in brief what we did in reviewing the bill and in working with the departments and getting the NPA and SAP's inputs. Sigrid Roberts would like to add to anything from a policy or a cyber law perspective.
Thank you, Barbara. I think, Mr. Roberts, do you have anything to add?
No, Ms. Chairperson. I believe we worked together with Dr. Lutz, and she explained the amendments well, and we agree with that.
Thank you, Mr. Roberts. Our members, just in terms, let's thank you, Dr. Lutz, for this very comprehensive presentation. But our members, I just want to draw your attention to the fact that in terms of the documents you received, there has, and what has been presented by Dr. Lutz, she did indicate that in clause 16, subclause 2BA, AA, the removal of transsexual person as it is covered by the umbrella term transgender person. I just want to draw your attention to that because you received these documents ahead of time, so that if you have any points of discussion around that, bear that in mind. And I think the schedules that we did receive also had some amendments, largely due to as a result of non-binary grammatical amendments, and these are. There has been a discussion around this, and these have also been removed, and this is largely due to the fact that those pieces of legislation don't necessarily use non-binary language, so it's just from a logical kind of perspective. But please bear that in mind, especially in terms of the documentation you received. Our members, we have Deputy Minister. I don't know if there's anything you would want to add before we go into the issue of the questions.
Chair, nothing from me at this side, at this stage.
Okay, thank you, Deputy Minister. Our members, as I've indicated when we began this meeting, that we have received some questions from Honourable Mikolakis, which we did refer to the department. A lot of the questions raised are of a policy nature, but let me open it up also to other honourable members if they have any other questions to add, so that when the department does respond, they're able to respond to all the matters. If I can maybe get an indication from honourable members who would want to speak. Our members.
Dovu,
Chair.
Dovu,
Peter, the Dovu.
Nita.
I've noted you, Honourable Nita.
Okay.
Are there any other honourable members? Okay, let me start with Honourable Nita. Honourable Nita.
Thank you, Chair. Good evening. Mine is only one question, Chair. That's all right.
We can hear you,
My
Honourable
question
Nita.
is, Chair. Can you hear me?
Yes, we can hear you very
Can
clearly.
you hear me? Okay, thank you very much. My question, Chair, is how does the proposed bill address the issue of cybercrime where there are mutual agreements, treaties between South Africa and any other country, Chair? Thanks.
Thank you, Honourable Nita. Honourable Dodovo.
Thank you very much, Honorable Chair. Let me once more welcome the presentation. I think it is always good and refreshing to deal with this particular important matter. On the 11th of March, when we were engaging with this particular bill, I expressed the following, that one, this bill is very much important because cybercrime has got serious negative implications to South Africa, especially to the economy as a whole. And if we are not going to make some urgent, decisive interventions, we will not be in the position to deal with the issues of crime very effectively. And I really want to repeat that the sooner we finalize this process, the better. I think we need to expedite it because cybercrime, fraud, and all those related, bullying, and all those related crimes related to cyber environment are quite serious and they need to be given attention. I think this bill deals with how we must rationalize cybercrime in the country, which is very good. But I raised a concern, and my concern is that my concern is I don't see how we are demonstrating the capacity to can deal with the crime itself. The bill has got an area where it points to the fact that the SAPS is a point of reference in respect, point of contact in respect of cybercrime. But what does it mean? Does it mean that it is the SAPS or it resides to another department that is going to deal with all the issues pertaining to cybercrime? I'm raising this because the first thing that needs to happen immediately after this bill is passed into an act of parliament is that we need to embark on a very, very massive, rigorous campaign to educate our people about this, to ensure that the society as a whole understand the implication of committing crime from a cyber point of view. Because all these occurrences, whether it is insult, it is bullying, it is fraud, it is anything related to cyber, it is happening especially in the social media, whether it is Twitter, it is WhatsApp, it is Facebook, all of those. The crime is continuing perpetually. And for me, it demonstrates the fact that there is either lack of education or ignorance on the part of the people to just communicate recklessly and without due regard to the consequences of what they say, what they write, what they articulate at different platforms. Now, my view is that I'm not convinced with all these processes about our capacity to unfold a communication campaign, to educate our people, to make sure that the society as a whole understand cybercrime, its implications, and what we do in relation to this. This is a point that I continuously raise. The rest, they're okay for me, and we're waiting with apprehension to ensure that this bill becomes an act, and ultimately it helps us to deal with the crime from that point of view, Honorable Chairperson. Thank you very much.
Thank you, Honorable Dodovu. Honorable members, is there anyone else that would like to ask a question? Okay. I take it that there are no other questions. Can I then maybe hand over to there's a question, maybe let me hand over to you, Deputy Minister, first. And I think Dr. Lutz can maybe just add if she has anything else to add. Deputy Minister?
Thanks, Chair. I wanted to respond to Honourable Dodovu's question, and then if Mr. Robertson can respond to Honourable Nita's question on the mutual agreements. Cyril, I hope that's okay with you. With Honourable Mikalakis's written questions, which Mr. Robertson has prepared a written response. I don't know if that's been circulated, but we're not avoiding those. But just on sorry?
Maybe just to clarify that these questions are in addition to the questions that Honourable Mikalakis has submitted. So when Mr. Robertson responds, he can respond to that.
He'll respond to that too. Okay, that's fine. Just to Honourable Dodovu, this bill started off as the Cybercrime and Cybersecurity Bill, and it had a whole section on cybersecurity, which was more on the issues of capacity and things like that, which largely fall under state security. And it involved the setting up of a number of statutory structures to deal with cybersecurity. It involved setting up essential infrastructure for cybersecurity that was protected, and so on. The concern at the time it got approved by cabinet like that. It got introduced into Parliament at that point. There were a number of contentious issues in the public hearings in the National Assembly relating to the cybersecurity sections. And there were also concerns that some of the departments were not ready in terms of their positions on what was in the bill, which they'd agreed to in the bill, but under interrogation, they needed to give more input. So it was agreed with the then minister, it was the previous administration, the then Minister of State Security, that we would only proceed with the cybercrimes aspect. So this bill is effectively now I suppose you could say a sort of justice police NPA bill. And state security will have to come back with the cybersecurity provisions. So this bill is dealing with, and the reason we wanted to proceed and not wait was because of the urgency of ensuring that the crimes or cyber crimes are better defined to make it easier to prosecute. that it's easier for the police to investigate, and evidence and jurisdiction, that those questions are all resolved. So that's why it's not really, when this bill gets passed, we will advertise. I mean, we will do explanatory documents on it. There's also, by the way, the Ministry of Communications, who are also involved in the issue. Not so much in this bill, because it's also more the cyber security issues, but we would be looking at advertising what the crimes are, what the precautions are that you should take to foul of cyber criminals. You know, watch out for the phishing emails that might pretend they address that they've come from. It's actually from some place in Uzbekistan, for example, so it can't be your bank. So let me do that. I don't know, Sarah, if you want to add anything on that question, and then if you can respond to Honourable Nlita's question, and then it would be Honourable Mikalakis's questions.
Thank you, Deputy Minister. There's also the cybersecurity hub, as the Deputy Minister pointed out. It's under the Department of Communications. In terms of government policy, they have obligation to embark on public education regarding cybersecurity matters and cybercrime matters, as well as the protection of children in cyberspace. So this is an aspect, and we will use that structure once the bill is in place to actually educate the people further and expand or explain the provisions of the bill. Regarding the Honourable Ms. Nita's question regarding how do we deal with cybercrime, where there's treaties in place between countries. Currently, I think the treaty that is most adhered to is the EU Convention on Cybercrime, the Budapest Convention. There is a convention, the AU Convention on Cybercrime, which is a regional convention. It is for Africa. If a country adheres to a treaty or international instrument, usually operate in terms of the provision of that treaty or instrument. So on the one hand, yes, if there's a treaty in place and your legislation conform with that treaty and convention, you will use that as a basis for international cooperation between countries. So the AU Convention, on the one hand, will afford us the opportunity to use that convention on a regional basis to cooperate with other countries in Africa. We have not adhered to the Budapest Convention, although we did sign it. In terms of the Budapest Convention, there's a clause, I think it's Article 24, that expressly states that a country in place and the certain other conditions is met, and in terms of the bill, that conditions is met, you can use that as a basis for international cooperation. I think that explains the matter. Regarding the questions that I did receive from the committee, the first question relates to clause 14 of the bill. And that is the offence of where a person discloses a data message with the intention to incite damage to property or violence. And the question was asked, why did we remove intention from that clause? My submission is intention is there. It actually states intention to incite. But yes, it differs from the other provisions in the bill where we use the expressions unlawful and intentional. The offence that is criminalised in terms of clause 14 is the offence of incitement. That is the offence on the statute book. And that was interpreted by the courts as action where a person intends by word or conduct to influence other persons to commit an offence. It's not necessary, according to the department, that you include unlawful and intentional insofar as it relates to the distribution of the data message, due to the fact that that element is included in the offence of incitement. I did refer in the document to the case of State versus Levy, and the court there indicate that criminal liability includes unlawfulness and intentional conduct, and even if legislation does not specify it, the state must prove that elements in order to secure conviction. The second question relates to clause 26. That relates to protection orders, and 26 relates to persons that can apply to the court for amendment of the protection order or setting aside of the protection order. And we specifically exclude the person that's accused of the offence. And the question is now, why did we exclude the accused? First, I want to point out that the protection order in clause 20 is of an interim nature. It only applies till criminal proceedings is finalized. So the protection order will expire on the conclusion of criminal proceedings where a person is convicted or acquitted of the offence. Since clause 23 provides for additional orders which a court can issue. And obviously, one of the reasons to exclude the accused from that provision that in terms of which a person can ask for amendment or setting aside of the protection order is due to the fact that the issue that needs to be decided by the court to issue the protection order is something that is going to be decided in the future by the trial court and criminal proceedings. If you allow the accused now, before the criminal process, to apply for amendment or setting aside of the protection order, the court will, in a civil case, actually decide on the merits of the offence in question. Clause 20 do provide that a person can actually appeal to a high court in respect of an order, and that will include the accused as well. So there is relief in that instance, but yes, we excluded specifically for the reasons that was mentioned. The third question relates to double jeopardy, and this was raised in respect of clause 24 that deals with jurisdiction of courts, where we grant courts extended jurisdiction to hear cybercrime matters. Double jeopardy rule is not per se applicable there, but I will give an explanation in respect thereof. It may happen that a person is prosecuted overseas for an offence, and he may be acquitted or convicted, and if he comes to South Africa, the person can again be charged in South Africa. The Criminal Procedure Act, Section 106, is quite clear on that matter. 106 set out certain pleas that accused person can raise in respect of a charge, and that is that he was previously acquitted of the offence. Acquit is the terminology used, or that he was previously convicted of an offence. It's convict. If you look at the Constitution, it's Section 35(3)(m). The Constitution, as part of the fair right trials, expressly state that a person cannot again be charged or prosecuted in respect of offence where accused was either convicted or acquitted. So that's a constitutional right. I did refer to the cases of State versus Basson, who described the ratio behind Section 106. And in the case of State versus Nadeau, the court did guidance. What is a previous conviction or acquittal in respect of a specific charge? And it's mainly that the elements of the crime must be substantial, similar to what the new charge against the accused will be. To an extent, if you look at international cooperation, which I will discuss later, double jeopardy is one of the rules that either prohibit, or let me rather say that prohibit international cooperation. That's part of international law. If a person has been convicted or acquitted of an offense, he cannot be extradited per se to stand trial in another country in respect of the same offense. The question was asked, why do we change clause 26 to allow the South African Police Services now up to 12 months to issue standard operating procedures? I do want to refer to that clause, and there's an extensive consultation process that must take place. It's the Minister of Police must, in consultation with, amongst others, the Minister of Justice, the National Director of Public Prosecutions, issue the standard operating procedures, and that clause specifically provides for extensive public consultation process. Really, if you embark on public consultation, you will lose at least 3 months in most instances. And if there's going to be further discussions, that will take up some more time. My submission is that 12 months is a reasonable period. However, if the standard operating procedures is finalized before that, I'm sure that the Minister of Police will issue it. And I did indicate previously that the department will assist the South African Police Service with the drafting of the standard operating procedures. Question 5 relate to clauses 32 and 33. And the amendment that we effected is that police officials may, in certain circumstances, without a warrant, access and search and seize computers or computer data storage mediums. I do discuss the overseas authorities in that regard in respect of different countries. On the one hand, you get Canada. There's 2 cases. The one says, yes, you can access without a warrant. The other one say, no. I also referred to the US authorities, and mainly Riley versus California, which has established the rule that a warrant is necessary. In South Africa, I do refer to the case of State versus Miller, which was specifically decided on this point in respect of a cellular phone, where the court say it's all right, you can search and seize without a warrant. In terms of the Criminal Procedure Act, Section 22B, a police official may, without a warrant, search and seize an article. The conditions that must be met is that he must believe that a warrant will be given to him if he apply for that warrant, and the delay of applying for such a warrant would defeat the objects of the search. I believe during the public consultations, the main concern was that the police may access commercial networks without a warrant. I did refer to the fact that there's other measures in place in terms of the bill, like expedited preservation of data or articles, which can be resorted to, and that can be used. And also there's the provision for oral applications for warrants that can be utilized. My submission is, if you look at the current South African position, the Miller judgment, as well as Section 22B of the Criminal Procedure Act, that is probably sufficient authority for us to allow for search and seizures in exigent circumstances without a warrant. I must refer to the conditions that must be met before a police official may embark on a search and seizure without a warrant. Similar to Section 22B of the Criminal Procedure Act, the police official must on reasonable grounds believe that a search warrant will be given to him if they apply for such a warrant. And the second requirement, it is not reasonable practical, having regard to the urgency of the case or the existence of exceptional circumstances, to make a written or an oral application for a search warrant. Oral application limits the powers of the police, so they must show that they couldn't make the oral application. Regarding the sixth question, which is divided in two categories, and the main question is whether the fact that we did not adhere to international agreement will impede on the effective implementation of the Cybercrimes Bill. The second one is whether the South African Police Service have the necessary capacity, and if not, what if that will impede on the implementation of the Act. I did explain previously regarding, in respect of double jeopardy, that double jeopardy is also applicable to international cooperation, to the sense that it's based on two principles. First one is the principle that if double jeopardy apply, you do not extradite a person. And the second element that is necessary is that there must be similar offences between countries before you can actually embark on international cooperation. Since the bill is based on international principles, I think the bill is in line with the legislation of most countries. And although if we do not sign a treaty or adhere to a convention, the bill do provide that on a reciprocal basis, the executive may enter into agreements with foreign countries to deal with international cooperation as a basis. I did explain the AU Convention, and I did explain the provision in the Budapest Convention that do provide for international cooperation. The second aspect regarding capacity. Capacity, obviously every country in the world is struggling to come to terms with cybercrime, and really I do not think there's one country that can say that it has sufficient capacity to deal with cybercrime. Even the UK has problems in that regard. Clause 55 of the bill put certain measures in place to ensure that the South African Police Service do acquire the necessary capacity to investigate and deal with cybercrime matters. The Minister of Police is accountable to Parliament in that regard. Thank you. And that's it. Thank you. I'm stuck.
Thank you. Thank you, Mr. Robertson. Mr. Robertson? Are you
sorry, I don't know. Seems that we probably didn't hear everything.
No, we did. We heard.
Some network problems. Okay.
I think from outside we heard you well, Mr. Robertson. Thank you very much. Dr. Lutz, is there anything else you would like to add?
Thank you, Chair. I agree with what Advocate Robertson has presented to the committee. I did have the opportunity to peruse his replies to the questions also sent ahead of time, and I find it legally sound and rational, so I completely agree.
Okay, thank you. Thank you very much for those comprehensive responses. Honourable members, are there any follow-up questions first before I ask other members for other questions? Honourable Mikalakis, you've indicated that you have a follow-up. Honourable Dodo, okay.
Mtetwa.
Yes, Honourable Mtetwa. All right. Honourable Mikalakis, if I can start with you.
Thank you very much, Chairperson. Firstly, let me say thank you very much to Advocate Robertson for the very comprehensive replies that I have received. I think we owe him a very, very big thank you, and it is what they have in people like Mr. Robertson. So thank you very much for those replies. Then, Chairperson, my only question is just with regards to my fifth one, and that's the warrantless search and seizure. And it's not so much with regards to the response that I received. I'm happy with that. The question that I have is more in terms of if a police officer were to act in bad faith, what would the consequences for him or her be? And then just an observation with regards to the last question, and that I think we as a committee can consider at a stage later, when even after the bill has been passed, to perhaps we're in a fortunate position where we also have oversight over international relations, to perhaps call the department to the committee to come and talk to us with regards to these agreements. The African Convention, we haven't signed it and we haven't ratified it. And I can't for the life of me understand why, with regards to the Budapest Convention, we've signed it, but we haven't ratified it. I think that convention would go a long way in assisting South Africa, and especially with the implementation of this bill. The alternative to that would be a whole string of international agreements. So I do think it would become necessary at some stage for us not only to follow up on the progress made by the Department of Police, but specifically with regards to the Department of International Relations. So everything that needs to be in place for the implementation of this bill on their side, we can also monitor. But I would think look at it even after the bill has been passed. But thank you very much to Advocate Robertson for the responses and for his excellent work on that side.
Thank you, Honourable Mikalakis. Honourable Mtetwa.
No, thanks, Chair. Mine is also on the issue of one, the issue of malicious communication protection. How is that being done? When you said you'd be providing protection on malicious communication, maybe may I get some examples of that so that I can familiarize myself with that one. The second one, Chair, is the issue of search and seize. What is the standard practice internationally? Because currently the COVID-19 has taught us one thing, that amongst the government officials that were found on the wrong side of the law, most of them were the police. If you give them a policy like this, would it not be easily to be abused? If yes, what level of protocol that the search and seize it must be installed? Which level? On their superintendent or whatever level, or anybody can come across it and then just to say this is the this thing I found it on a crime scene. Therefore, I arrest without the warrant. I also that was my concern, Chair. That how is that going to be done? Thank you very much, Chair.
Thank you, Honourable Mthethwa. Is there any other honourable member who would want to?
Yes, Dodovu. Just a small point, Honourable Chair. Yes, I think to a large extent, Honourable Mikalakis covered me when he said that we need an engagement with the Department of International Relations as it relates to the double jeopardy. As countries, we differ in terms of how we dealing with issues, and even our laws are quite different. And I would imagine a situation whereby a country prosecute a person not find guilty and its laws are in total conflict or in variance with the South African laws. What do we do? And will that principle of double jeopardy apply or not? For me, that is quite important. And therefore, the point that we need to take this particular matter forward with the Department of International Relations and Corporations, especially with regard to the international protocols, conventions, and agreements that are concluded between South Africa and different countries, as well as the multilateral agreements that are in place. We need to have that engagement and sort it out quite properly and not in precision. What is our standpoint as a country? My point is that point is okay. It needs to be followed up in that sense, Honourable Chair. Thanks.
Thank you, Honourable Dodovu. If there's no other honourable member, I'm going to then hand over to Cyril once again to respond to the follow-ups.
Chair, can I just deal before Mr. Roberts does? Just the issue of the Budapest Convention. Now, the issue basically, it's an international relations issue. This was a convention of the Council of Europe, which other parties can sign. But the issue that some countries are raising is that they didn't have the opportunity to participate in the drafting of the treaty. They would rather have a UN treaty on cybercrime. So it's basically caught up in that issue, which is more of an international relations issue.
Thank you, Deputy Minister. Thank you, Ms. Chairperson. It is correct, as the Deputy Minister pointed out, it is actually an EU convention, in other words, a regional convention. There is currently steps under the way under the auspices of the United Nations to try to establish a universal convention that deals with cybercrime. This may take some time. Regarding warrantless searches, if a person do contravene, let me say, the person embarked on a warrantless search and he was not entitled to do that, what will happen? Obviously, if you look at the current law in South Africa and the various court judgments, the person will be guilty. Not guilty, will commit a delict. It's the same as an ordinary warrant, or where you search and seize for an article and you're not entitled to that in terms of the Criminal Procedure Act. The South African Police Service will incur civil liability in that regard. Regarding what does the bill do further to address this, I think if the honourable members looked at clause 37, there's a specific provision that actually criminalize search and seizures where a person is not entitled to do that. And that clause also do provide for civil liability, which a court can give an order in terms of criminal proceedings, and Section 300 of the Criminal Procedure Act will apply. Malicious communications, I think it relates to Mr. Matetwa's question. The protection, how does the bill afford protection to such communications? That is dealt with in clauses 14, 15, and 16, which do specify what is malicious communications. In the schedule to the bill, the Sexual Offences Act is also amended. There's a new section 11A that deals with harmful distribution of pornography, which is more serious offences due to its content. And in both instances, the victim can apply to a court for a protection order pending finalization of criminal proceedings to first prohibit a person to further distribute the content in question, and secondly, for an electronic communication service provider to either block it or take down malicious communications. And up till the criminal, if again, that order is valid then till the criminal proceedings is finalized. On finalization of the criminal proceedings against a person, the court may issue an order for that person to destroy the malicious content, as well as for electronic communication service providers to destroy or ensure that nobody get access to such malicious communications. Regarding the questions COVID-19, I think it also relates to the questions of Mr. Nikolakis. Again, the bill strictly regulates the instances under which you can search and seize computer systems, data, or anything that is provided for in the bill. I must remember, the bill is only one part of the electronic communications set up in South Africa that do provide for the investigation of offences. The other piece of legislation is the RICA, and in terms of RICA, if you intercept communications without a direction from a judge or obtain communication-related information, you commit a serious offence. And obviously, civil liability will also follow in terms of RICA. And I think the Deputy Minister has explained the Honourable Mr. Jodovo's question. Thank you, Mr. Chairperson.
Thank you. Ms. Lutz, anything else you'd like to?
No, I think, Chairperson, that especially with the malicious communication, Sarah covered that quite well with the crimes that are set out there and the protection orders for the international relations issues. I agree with what he has said and the approach of the members of actually also speaking to international relations. I think that he covered everything quite well.
Okay. Thank you very much. Any other questions you want to make? Okay. Can I get an indication from Honorable Goya? Honorable Goya? Okay, if there's nothing from you, Honorable Zandamela. Honorable Nita.
Thank you, Chair. I'm fine. My question was clarified, Chair, and I think they did a very good job in terms of presenting and also responding to our questions, Chair. Thank you very much.
Thank you, Mayor. Honorable Mtetwa. Anything?
Thank you, Chair. Thank you, Chair. No, I still need further engagement on the issue of seized search and seize, Chair.
Sure. Honorable Mola. Honorable Mola. Okay, Honorable Officer.
Thank you, Chair. I'm covered. Thank you.
Honorable Mikalakis.
I'm satisfied. Thank you, Chair.
Honorable Zadovu.
Chair, I'm okay, except just to say that once more we must commend the department, especially the Deputy Minister, who's always with us all the time, engaging with us, listening to us. And what I also like about him is that even if it is not matters pertaining to the department or the ministry, he's always there. Honorable Minister, as you said, this falls under your department. That is the bill. Once it is an act of parliament, I would love to see that situation whereby a massive campaign is rolled out so that the people understand the implications of this act, and that it is quite important that they observe to it. Other than that, I'm quite satisfied. This is a good job from the department on our chair. Thanks.
Thank you. Honorable Suleku.
I'm happy, Chair. Thank you very much.
Honorable Mpayela. I know somebody left the meeting. There's another meeting that's happening now as well. Honorable Matsamai, are you with us?
Yes, I'm with you. But there's
Anything
nothing I
say?
can say at this moment. I did understand what they were saying and I cannot comment anything. Thank you.
Thank you, Honorable Matsamai. Once again, thank you, honorable members. I think we've exhausted deliberations on this matter. Let us once again thank the Deputy Minister, Mr. Roberts, our parliamentary legal advisor, for the submissions and discussions in terms of the proposed amendments to the bill. And committee members yourselves, in terms of the deliberations on the proposed amendments. I think the department has adequately covered our concerns today. And I just want to reiterate that, you know, it's clear from the presentation that some of our previous concerns that relate to SAPS and the National Prosecuting Agency being satisfied with the bill has been addressed. Issues around gender neutrality and the non-binary language that has been incorporated throughout the bill, which is also recognized internationally. And the amendments, while they mainly provide for technical and consequential issues, but they also address key aspects in terms of the written submissions that were raised during the oral hearings on the bill. Members, there are a few clauses where substantial amendments have been made in terms of this bill. I wouldn't want to necessarily go through it because it was extensively covered in terms of the presentation, but just to also say that we're pleased with the substantial work which has been undertaken on the bill, and we look forward to finalizing the bill soon. And as honorable members have indicated, that we should also look into trying to expedite this process. And all members, if this bill is enacted, I think this would be then the first non-binary piece of legislation within our democratic dispensation, which I think would be a beautiful achievement. since we've exhausted our deliberations, our members, I'd request that you allow my office to put the report together. You're aware that we're meeting tomorrow to continue with processing this bill, and possibly in the next meeting, which is tomorrow at 1800 hours, we could look into matters of adoption. And once again, on members, as reiterated by yourselves, this is a very important bill, and we will try and expedite it and ensure that the bill is processed in due time. Let me thank you all, but also in terms of what was raised by honourable members, as a committee, we need to do the follow-up with the Department of International Relations in terms of the ratification of international agreements, conventions, and protocols that will support the implementation of the cybercrime bill. Deputy Minister, before I conclude, there is one issue that did come up when we dealt with this bill. It's not related to the cybercrimes bill, but it did arise. And what was raised in terms of our public hearing deliberations was that provision should be made for victims in the live broadcasting of incidents of sexual assault and rape via social media and the devastating impacts thereof. And the department at that point did respond, indicating that an amendment of the Sexual Offences Act should be considered to address this concern. And I think this is just one area that as we continue engaging with yourselves, we would also want to further discuss. I think with all that said, honourable members, once again, thank you, Deputy Minister, Mr. Roberts, Dr. Lutz. Thank you very much for your inputs. And let me then declare this meeting closed, and we will meet tomorrow at 1800 hours to take this process forward. Thank you, honourable members, and good evening.
Thank you, Chair.
Thank you, Chair.
Thank you, Chair.
Thank you very much, Chair.
Thank you, Chairperson.
Good evening, Chair.
Thank you, Chair.
Good evening.
Good evening,
Good evening, honourable
Chairperson, for holding this important meeting today. And thank you, the Honourable Zandamela, because the two is no longer in this meeting.
Good evening, honourable Matsumai.
MZS. The ministry, the DDG. Yesterday there was a meeting. I raised a lot of issues sharply. Northwest is one of the adversely affected provinces that the issues of water, and that by prioritize Limpopo, the Free State, especially, and then about the next Northwest. Now they said the submissions are submitted 3 things basically. 1 clear water tankering, Komadibe, which is my constituency. 2 ka submitted taba ya ko Buphirima. Ba spent about 300 million rand for the installation of pipe. It's not complete, but Shotaka, I think about 140. 140, it means that will be a futile exercise. But go for that discussion, we need to replace your asbestos pipes. In that sense, you need funding. Now I discussed the matter politically.
Mama wa mwenza ga. Aska Murume.